When I left off on the last video, I was talking about what was in the Court of Appeals from the May 21st order 2026. And in that order, or that opinion is what it's called from the Tennessee Court of Appeals, it talks about all the motions that I filed. And it talks about that addressing an exhibit, it was Exhibit E, of where Mrs. Longmire addressed the Tennessee Board of Responsibilities and told them of the news that she knew, or she wrote a letter and let them know that she knew that Dr. Islam's death on the 12th, 2024. But she did not tell the court. So I'm waiting on an answer from the Tennessee Board of Responsibilities, but we'll see what they say since I've been ruled upon. But since in the meantime, when I got the order, May 21st, I filed today a motion to rehear. I filed on several grounds, and I just want to share with you one of the grounds. This is really important. The suggestion of death is not subjective. It is very important. The court said that I had hallucinations AI citations. And let me break that down. That means when you go to court, you have to have case law. Case law is important because that's how you prevail on your cases. That's how you win. You win from rules, statutes, codes, and case law. They stated that me, had hallucination AI citations. That's what I had cited. Follow me on this one. One thing for sure, and two things I can tell you. None of my citations were AI hallucinations in any form. So we get down into the nitty-gritty of this. Excuse my vernacular. Did the court read my citations? And I'm going to particularly pull out one case. It's called the Jones case, and I'll just shorten it up and use the Jones case. The Jones case is a Tennessee Supreme Court case that says that when one dies, the substitution has to happen. That means when you die, and if you're in litigation, that when you find out, you have a certain time frame to get this to the court, which I met, and that person has to be substituted. Now, when the Court of Appeals stated, they said, and I'll read it, it says, artificial intelligence. It says, it's widely reported phenomenon in which artificial intelligence programs create new information that has no basis of fact. Well, I want to tell you something. You're wrong. Because now in my rehearing, I have shown the court that every last one of my citations were real. So therefore, the Court of Appeals, if they looked at it, how could they come to that conclusion? Or they did not look at it. How's it a pro se litigant in all this appeal and this opinion states that I am submitting before the court AI opinions, AI citations, and then they call them hallucinations. Well, I went back and got all of my briefs and all of my information that I submitted before them. I knew this for fact. I studied extremely hard. I cited every case. Out of all my cases, every last one of them were true. They were not hallucinations. But this Jones case, they definitely did not want to look at it because it was a Tennessee Supreme Court, which supersedes or governs the law for the state of Tennessee, and the Court of Appeals has to take note of the statute, of that opinion. That opinion stated that when a person dies, substitution has to be made. It's not subjective. It is in the opinion. So you have the Court of Appeals here, the Tennessee Supreme Court here. So technically and rightfully, the Jones case which was in my brief, as well as all my other cases for supporting the um, suggestion of death, and to overturn the case and remand back um, into the trial court. And I wasn't trying to retry the case. Let me say that for sure, because people are watching this video. But what I was doing was showing that you had an attorney that allowed her client to die, and she said she knew it, but she didn't. The judge struck me down and said you can't use that because it's the Tennessee Board of Professional Responsibility information. But they made it public, and there was a woman by the name of Michelle Todd that went and got the document out of the public record, and she gave me a copy with an affidavit. I supplied it to the court. Note, an affidavit. So the court struck me down on putting out this information, but then it was public record. The Court of Appeals struck me down, and it was public record. I showed and gave them evidence of Michelle Todd, who is a public person that lives in Nashville. Not a public person is in an office, but she's a person that lives here in Nashville. And as she went and got the information, she went and gave it to me with this being said. She said, it's public record. The document, what is public record? The document that the judge said that I could not use. So therefore, the Court of Appeals had all authority to look at that information. Matter of fact, they had authority, if they wanted to, in their discretion, to go ahead and look at Exhibit E and see where Mrs. Longmire stated, I knew the day that Dr. Islam died. I knew the day. I knew the day he died. But I did not tell you. I didn't feel like I had to. Now, what if I had have done that? What if I would have hidden the death? Do you know that's called concealment? Fraud upon the court. Intentional fraudulent concealment. That is injustice. Because you cannot rule on a dead man. And then when the lawyer knew, why did the lawyer not tell anyone? Why did she not tell the trial court? Why did she not tell the appeals court? He died while they were in the appeals court, while he was in the appeals court. But she didn't tell. They didn't reprimand. They didn't do nothing. They dismissed my case knowingly. But the Jones case, remember the case from the Tennessee Supreme Court, says not so. You have to substitute. So why did the Court of Appeals listen to this? Why did the Court of Appeals say this? My case law was AI hallucinations. The fact is that I'm before the Court of Appeals as of today. They can deny me a rehearing, but I'm telling the world because the world knows the courts are public, not private. They hid or they did not acknowledge that information. Why did the Court of Appeals say every citation was AI? Are they saying that I'm not able or astute enough to read, to write? The proof is that you can use AI. A lot of lawyers, a majority of lawyers use AI, but you have to use it correctly. One thing that I did correctly is this. I cited a case that I believe would have thrown everything that they filed out. But I forgot to tell you, the Court of Appeals dismissed or struck every filing of Mrs. Longmire because they found out I filed a suggestion of death, not the opposing counsel. Now that is serious. I am the plaintiff. I filed the suggestion of death, whereas his own counsel, Dr. Islam counsel, did not file. There's more to come, and I'm going to keep telling every bit of it so they can help someone.